Good afternoon and welcome to the Appellate Division First Department. Most of you who've been here before know how this goes. I'm going to call the calendar and ask for your requested argument time. Please note that currently there is 6 hours of requested argument time, which would keep us here till about 8 p.m., okay? And I can assure you that your colleagues at the end of the calendar don't want that, okay? So please ask for the time you need, not the time that you want, understanding that the clock is for you, not for the court. So if your arguments are brilliant and it makes us have more questions, it can exceed the time that I allot you, okay? All right. People versus Alejandro Campos. Okay. 4 and 1 and 3, and thank you for that. You listened. Draper versus Haran. Okay. All right, let's do 5 and 2 and 4. M. Children is submitted. Ruggerino versus Prince Holdings. Submitted. Lopez versus 18-20 Park 84. Submitted. Bronx Lebanon Hospital versus New York State Catholic Health. Okay. 7 and 2 and 7. People versus Angel Figaroa. Okay. 4 and 2 and 4. Wilmington Savings versus AmTrust Title. Okay. Rebuttal time? Okay. 5 and 1 and 5. Cuomo versus James. Okay. Okay. 7 and 2 and 7 and 2. Creekstone Juban LLC versus XL Insurance. Okay. All right, 6 and 2, 6 and 2. Abrahami versus Feldman. Okay. 5 and 1 and 4. People versus Brandon Givens. Submitted. Bay Towers versus Pike. Okay. 5 and 2 and 6. Kaplan versus 55th Street Apartments. 4 and 1 and 3. State Farm Mutual is a submit. First case on the calendar, People versus Alejandro Campos. You may proceed.
Good afternoon, Your Honors. My name is Nancy Little, representing Mr. Campos today. I'd like to focus on point 2 of our brief, asking this court to reduce Mr. Campos's 26-year aggregate sentence. First, I'd like to note that respondent contends that this court may only modify a sentence if there's a clear abuse of discretion by the sentencing judge. The Court of Appeals made clear in Delgado that this court may exercise its discretion without any deference to the sentencing court. And I reaffirmed that recently in People v. Brisman, which it issued in January, saying that neither extraordinary circumstances or an abuse of discretion is necessary for this court to exercise its discretion.
Now tell us why we should exercise that discretion.
This case involves Mr. Campos, a 21-year-old who, until the instant offenses, the 2 robberies, was an upstanding citizen. I mean, the sentencing court said his life was very exemplary. He went to school, he graduated high school, he was in community college, he had been working since he was 14, he had a good job.
Anything you can say about the facts of both cases that would warrant us to reduce the sentence?
And let me just add to that, that while I would normally be more receptive to this argument, it's hard under the circumstances here where your client takes the stand and tells the most preposterous story, which he would have been better off not testifying at all. It was so disrespectful to the court.
So I guess I would first ask Your Honor to consider, if you put that aside, what do you think would be an appropriate sentence?
Well, let me see. I have a dead young man who got beaten to a pulp after giving your client good grace and not reporting the car accident, right? That is this case, correct?
Okay.
Well, we understand that one of the complaining witnesses, Yang, was killed at the scene, and then there was another one where there was a car accident, and at that car accident, that individual was beaten to a pulp, to use my colleague's phrase.
Yes. You're beaten to a pulp. Is that descriptive?
Set up by your client.
Yes.
My
And the
client was
car
not
accident
present
had to
during
do,
either of the-
the car accident had to do with a collision at a gas station, am I right? Where the defendant's van rear-ended?
Yes. He
the-
was not driving, but one of his friends.
Rear-ended the victim and then asked that the insurance policy, that the insurance company not be contacted, got the contact information from him,
Yes.
and then robbed him.
So, but I think you still have to look at his background, and that until he was 21 years old, he has an exemplary life. He meets Mr. Davis, who has 3 prior convictions, and all of a sudden, he's caught up in these robberies, and he's not present during these robberies.
Caught up or
but Mr. Davis is
counsel,
with the gun.
counsel, caught up or participated in these robberies?
Ex-
Because
Yes,
his friends who his friends who committed the beating
Yes,
would have gotten that address, but from one person, your client.
and the person who did the beating got a 7-year sentence, and my client got a 10-year sentence.
Uh-huh, and the person who got the 7-year sentence took a plea, correct?
Yes.
And I believe your client was offered a similar plea, correct?
So during deliberation.
Correct?
Wait, I'm not quite sure.
Was your client offered a similar plea deal?
No.
No, never. He
Not
was
until-
never offered a sentence less than the 26 that he got after trial?
During deliberations, the court offered him a 10-year sentence. To my knowledge, that was the first
Okay.
plea offer. I'm going to rely on my brief clearly, but I would point out that I don't think this court, based on its own prior cases, can consider Mr. Yang's death, as tragic as it is, and I don't want to,
Of course we
undermine
can. He
that
was
at all.
acquitted on that.
Yes, he was acquitted on that.
We know
I think
that.
that has to drop out of the case. The jury found he wasn't culpable for the death, and he wasn't culpable for Mr. Davis bringing a gun to that robbery. And I
Okay,
think if
you'll have time on rebuttal.
Okay, thank you, Your Honor.
May it please the court, Larry Glasser for the respondent, people of the state of New York.
Counsel, why shouldn't we grant this excessive sentence request? It's 26 years.
Yes, because, Your Honor, I would submit the sentence in this case was not excessive. As a few of your colleagues have mentioned, this was an extreme.
Don't mistake my questions for declarations on your side.
No, I
Please
understand, Your
don't
Honor.
do that.
I was going to adopt those as my
Okay.
declarations. I'm certainly not putting
right.
words in the court's mouth. But these were 2 vicious, violent robberies committed within the course of a week that this defendant set the first one in motion, as was discussed, by getting the victim's address after the.
But he was found not guilty of the felony murder, and the co-defendant got 35 years, and he gets 26.
Right. Well,
9 less.
even though he was found not guilty of the felony murder, the court can consider the fact that someone died as a result of this robbery, because a robbery is a forcible taking. The amount of force that was used and the extent of that force is valid for this court to consider. If someone commits a robbery by threatening physical force against someone, all else being the same, they would probably deserve a lighter sentence than someone who inflicted physical injury.
And counsel, the 26 years represents consecutive sentencing for two separate incidents, right?
It does represent consecutive sentencing, that even though they're consecutive, it was less than half of what the defendant faced.
What did he face?
He faced a potential of, or it was approximately half. He faced up to 25 years on each of the robberies, which could be consecutive, as well as up to 2 to 4 for the possession of the stolen credit card relating to the first robbery. And what you also have here is that the trial court was well aware of and considered all of these factors, and frankly made a very extensive statement at the time of sentencing.
But counsel, we don't have to give deference to that, as you heard your adversary say regarding the Court of Appeals decision and what our standard is for reviewing sentence, right?
You don't have to, but certainly one of the things this court would consider is, for example, factors that the court below didn't consider that your honors think is appropriate. And down below...
Well, that's not a part of the standard. We have absolute discretion to make a determination on excessive sentence, right?
Yes, you do, in the interest of justice. And I would submit the facts of this case, the seriousness of the harm that was caused, the fact that this defendant was frankly the mastermind of these two violent crimes.
How do we know that?
We know that because for the first one, the only way that the actual perpetrators got the victim's address and knew when and where he would be is from this defendant and the car crash at the gas station. This defendant had the proceeds of that robbery within an hour later, the debit card. As far as the robbery that resulted in the fatality, the defendant admitted in his statement to the police that he and the other defendant were driving around looking for someone to rob. He knew the co-defendant had a gun. He saw the co-defendant leave the van with the gun. And again, less than 24 hours later, he is selling the stolen cell phones from both of these robberies. So he put them in motion. He planned them. He benefited.
Before you sit down, a stolen cell phone, there was evidence regarding that being sold on Craigslist?
Yes, and that
And
was
it was identified as the actual cell phone to the victim, correct?
Yes, they were by the IMEI and serial numbers of the phones. They were, and subpoenas and phone records.
One
from
last question regarding his age as well as his lack of contacts with the criminal justice system. How should we weigh that in our analysis of whether this sentence was excessive?
Well, I think that should be certainly weighed in considering a sentence, as the trial court did. But in this case, the seriousness of the facts, the defendant's commission of perjury, which the sentencing court extensively discussed, the fact that that perjury was blatant and it went directly to the core issue of the case, which was, or one of the core issues, the veracity of the defendant's confession. And this is not an example or a situation where the judge called it perjury because the judge did not believe the testimony, but it's perhaps open for argument. Here, the defendant's father wrote a letter to the court for which he believed would be on the defendant's behalf, recounting the defendant's admission to him, which was directly contrary to his trial testimony.
Thank you.
Thank you, Your Honors.
You have a minute, counsel.
Just briefly, respondent refers to the defendant knowing that Mr. Davis had a gun. The jury rejected that testimony. And I think for this court to consider that really denies Mr. Campos his right to a jury trial. I think what's before this court really is kind of a weighing of punishment versus rehabilitation and deterrence. I think if you look at Mr. Campos's background, his potential, if not certainty of rehabilitation, is apparent from the record. And yes, he needs to be punished, but 26 years is a really long time for someone like Mr. Campos. And I ask this court to either run his sentences concurrent or modify each sentence to have a 16-year determinate term.
Thank you.
Thank you, Your Honors.
Draper versus Haran. You may proceed, sir.
Thank you, Your Honors. Good afternoon. May it please the court. My name is Eitan Ogun. I represent the plaintiff appellant in this matter. The appeal is based on cumulative total of significant and prejudicial errors that occurred at the trial. I identified three main areas on my appeal. The first had to do with not allowing his treating doctor to testify about records that were
The
already in
record
evidence.
demonstrates that this treating doctor was unaware until the time of trial about the 2008 accident. Am I incorrect about that?
It's mentioned in his notes that there was an accident. He just didn't review the records beforehand.
Okay, so if he didn't review the records, then those records were not at all utilized in the formulation of his opinion, correct? Obviously, if he didn't see the records, they could not have informed his opinion about causation or injuries, etc. Can we agree on that?
Up until the time that he reviewed them, which was before trial, correct?
Right, but at that point, it's not like the plaintiff didn't know he had a 2008 injury, right? So the fact that the doctor doesn't get to see the records is the fault of plaintiff's side, plaintiff's counsel, plaintiff, whoever. The point is, it wasn't considered as a part of his opinion. He did not notify the other side that he would opine on it since he didn't know what those records said. So based on our case law, you can't opine on something that you didn't consider in your opinion.
The defendants were the ones that introduced evidence regarding the 2008 accident records.
But it was also in their report. It was in their report.
The radiologist, not any of their orthopedists or neurologists. No, the only person that testified about it was their radiologist comparing films from 08 to 13.
But it was a part of discovery that was turned over, right?
Yes.
Okay, so it
What's
wasn't
the
a
next error?
surprise.
So we went through the first one. What's the next error?
Yeah, if I may just say one more thing about it, is that I believe that any doctor can testify about any records that are in evidence. So that, I just wanted to make that point.
Yes, but a doctor who has not utilized a record in reaching their opinion cannot then supplement their opinion on the stand. They must have given the other side notice that they would opine on it, and then they could say whatever they want. But as my colleague said, please go on to your next issue.
All right, the next issue were the comments that were made by defense counsel on summation. There was a big issue that defense counsel made on cross-examination about, you know, how much his expenses were, how much his car payments were, cigarettes, the house, and everything. My client was on disability for the whole time from the time of the accident in 13 until the trial. For 9 years, 8 or 9 years until the trial, he was on disability. He was not permitted to discuss that, and that issue was not permitted to be before the jury. At the same time, the defense counsel was trying to direct the jury to say, hey, he must really have some other job on the side without any evidence for that other than that he had all these expenses. And that was completely
Are
improper.
you saying he was asked questions and the court did not allow him to answer? I don't understand.
The defense counsel asked him about to itemize all his
And
expenses.
that was completely within their rights to ask. So what is the problem? I'm at a loss at what the problem is.
The problem is trying to use all those expenses that he would have been paying with his disability payments to say he must have some other job.
But
And that is
counsel,
what the defense
Counselor,
asked.
if I may, now, the court did sustain objections to those comments regarding the expenses
On summation.
on summation. No, that's usually a yes or no. From my reading, the court sustained objections. Yes?
So many of those were sustained, yes.
All right. All right. So now, after that, did trial counsel say, you know, listen, judge, you know, can I get a curative instruction, you know, move for a mistrial? Did that happen here?
He did not seek a curative instruction.
Okay. You'll have time on rebuttal. You'll have time on
Okay,
rebuttal.
no
Your
problem.
time is out.
Good afternoon. David Metzger for the respondent. May it please the court. I'll just address those two issues, and I'll do it very briefly. With respect to Dr. McCullough, it's what the court indicated. The key issue, the one thing that wasn't mentioned, is that there was no expert witness response served. So yes, treating physicians can testify about their own records and can testify about records.
They can also testify about any records that they reviewed as a part of their
part of
treatment,
their-
but there was no indication that these were the records that he reviewed,
The
right?
judge actually stated that it's clear that that was not the case, and the 3101D would have had to have been exchanged, which was exchanged regarding the radiologist. So that's the big difference, is that our radiologist had reviewed those films, and a 3101D for the 2008 accident was exchanged. With respect to the
Improper comments
the improper
estimation.
comments, yeah, if just focusing on the issue of the employment, just the chronology that was in the appellate brief was not correct. The initially came up in our or in the attorneys were handling a
Counsel, do
cross-examination.
you mind just speaking into the microphone?
Sure, because there was actually quite a bit of
Thank you.
of testimony that was contradictory to some of the testimony that the plaintiff had given. And the reason that they were asked is because there was an application for a car, which indicated that he was working, and all this other information that would suggest that he was working. So he was asked that on cross. Then it came up on direct. He had the opportunity to ask other questions regarding the employment, which he did. And most importantly, and this is the whole issue, or really the main issue, is that, as indicated, there was no motion for a mistrial. Not only was there not a motion, and not only was there not a request for a curative instruction, he was asked, the trial attorney was asked point blank, right after the objection that was made after the summation, is there an application? And not only said no, stated, I'm not going to move for a mistrial. So the case law is replete, with
Also, can
examples.
you address your friend's brief argument that the trial court erred in permitting the defendant's biochemical expert to testify?
I'm sorry, Judge, one more.
The biomechanical engineer.
Biomechanical,
Should he have been allowed to testify?
he certainly should have been allowed to testify. This court has already determined that he's an accepted expert, and that biomechanical engineering is accepted by the court. And then there are the actual, just to all the allegations regarding whether or not he put in the proper citations and all of that to treatises. I cite on the record, we included a respondent's appendix because this was a subject of a motion in limine, and that contained his affidavit. There's two particular articles that were cited. This is the respondent's appendix, page 62. It goes through bullet points of I have it as A through F, but all the different things that one would go through in order to make a determination, a biomechanical engineer determination. I can go through them with the court. I have them here correlated, but just, identify the injuries claimed. That's at the record, A854. He identified
Well,
the injuries.
I think the
won't go.
greatest argument was, how does an engineer opine on whether a particular type of injury was possible?
Well, that's been, again, this court has established that that's permitted. He does not need to be a medical expert. In fact,
And am I right that
the Vargas case.
that the car industry has employed these biomechanical engineers in order to ascertain and help design vehicles that are safer?
Not only in general, but this particular one was hired by Mercedes-Benz Daimler Chrysler. And the case that I'm referring to for this particular engineer is the Vargas case, which is cited in the brief. Thank you.
Thank you. Counsel, you have 2 minutes.
With regards to the biomechanical, our issue isn't that a biomechanical is incompetent to testify, it's how he did his analysis. His analysis was, he played basketball before, and
But that, our case law says that that's for the jury to determine. Once the court establishes that a proposed expert is qualified in the particular area, It's for the jury to determine what weight to give to the testimony of an expert.
There's one more component, which is the methodology. There is no methodology that he identified, that he used, that said, you cannot get this torn rotator cuff or you cannot get this herniated disc from this accident. There is no methodology there. He didn't say you need a force of X to herniate the disc, and the force here was half of X. I mean, where is that analysis? Where's the analysis? Anyone can come in there and say, well, okay, he used to play basketball, and now and that's a greater force, supposedly, than this accident, so how could he have been injured? But that's not a proper analysis.
Well, didn't he look at the crash data of both vehicles as part of his analysis?
The crash data to show the deformation of the bumper and to come up with a delta V, that doesn't
Which
tell you.
then leads him to how he came up with whether, in fact, the injury was possible based on all of those factors.
Where's the connection between the delta V and the force required to herniate a disc or to tear a shoulder?
And I'm
There is
sure
no such
that an
connection.
attorney asked that question on cross-examination, and the jury decided it was sufficient, because obviously you don't get to ask those questions of the court.
I believe the case law empowers the court to look at the methodology to make sure that the methodology is proper. Merely having the competence to testify and then having some data, you need to make that connection, and I don't believe it was made.
Thank you. Bronx Lebanon Hospital versus New York State Catholic Health.
Good afternoon, Your Honors.
Wait for your colleague to get here.
Oh, sorry.
Now you may proceed.
Good afternoon. May it please the court. My name is Janet Koljan of Robinson & Cole on behalf of the appellant, the New York State Catholic Health Plan. In this case, the plaintiff, the Bronx Lebanon Hospital, has sued the health plan to recover payment on approximately 2,300 medical reimbursement claims that it submitted to the health plan and claims the health plan improperly denied. The agreement.
Your adversary's position is that Bronx Lebanon Hospital didn't follow the internal procedures for claims, and therefore it's waived. What do you say to that?
That's our argument, Your Honor.
Okay, go ahead.
That is our argument, and the reason is because the agreements between the parties require the hospital to comply with the internal appeal procedure. It's an alternative dispute resolution procedure called an internal appeal. The hospital, a sophisticated contracting party, agreed to this procedure and routinely complied with it over the course of the parties' 25-plus year contractual relationship. Now, 25 years later, the hospital asks for this court to invalidate that provision as unenforceable under Article 49 of the insurance law. The reason the hospital asks that is because it doesn't want to lose half of the claims in this case, for which it failed to comply with that requirement.
I'd like to go in another direction.
Sure.
Exhibit M. 1,241 claims that were either waived or not timely submitted. And we know that there was 14 that really shouldn't have been on Exhibit M. And then there was a corrected Exhibit M. My question, and it's coming, my question to you is, you have to set the stage, you have to set it up. I've set it up. So the question is, once now we have the corrected 1214 claims, what, if any, evidence did the plaintiff put in to raise an issue of fact regarding those claims,
Remaining.
1214? The 1227 claims, the answer, Your Honor, is zero evidence. And that's why we're That's why we're appealing the decision to dismiss those claims.
If I can just take it a little step further, and I'll pass it on. But, you know, the 1227, I misspoke. What was the argument when you said, hey, it's not here? What was their argument about that?
Well, they speculated that there might be other claims on the list that they appealed.
When they have included it with the 14, just like they found the 14 when they have found the others?
Correct. That's certainly our position, Your Honor, right? This is a 13, this case is a 2013 index number. They've been litigating this case for a long time. They had 4 months to put in an opposition. They asked for 4 extensions, and we said, no problem. Give us what you got. Show us what you have. And they came forward with 14 pieces of evidence that, okay, those 14, we will deal with those at trial. We concede that there's an issue of fact on that. For the others, they've come forward with nothing. Other than speculation that maybe there would have been more had we done something other than a cursory review, which is the language that their CFO used in the affidavit they submitted.
Would you discuss the protocol that requires an internal appeal before any remedy can be sought in the courts?
The protocol for the internal appeal?
Yes. Is that something in keeping with the insurance law, or is that an anomaly?
No, not at all. That is perfectly, it is actually a creation of the legislator. That's what Article 49 and the public health law created the internal appeal procedure to basically to solve problems, to keep these denials, medical coverage issues out of the court system because it was too expensive for insureds, too expensive for health plans, and it was a burden on the courts as well. And so the legislator has an extensive procedure that they developed to say, you know, here's how much time you have to give the provider or the insurance. It's 45 days in the statute. We provide them 60. And here are the response deadlines. It's an extensive procedure. And the agreement and the provider manual all comply with that procedure. There's no suggestion that it's non-compliant. The only argument that the hospital has made is that it's invalid as a matter of public policy created by the statute.
But they abided by that procedure for your 25-year relationship, correct?
They routinely, they did, yes. And the hospital's CFO on page 278 and 279 of the record, he avers, we routinely comply with the internal appeal. Yes, they routinely comply with it because they are obligated to comply with it under the agreement.
You want to save your time for?
Yes, Your Honor, I do. Thank you.
Michael Keene from Garfunkel Wild for the hospital. Good afternoon. I'm going to start right where you left off. I think there's a misunderstanding of what the statute is. This internal appeal procedure, which you just heard admitted, complies with Article 49 of the insurance law. It was passed in 1997 as part of the Managed Care Reform Act. The goal of that act was to give hospitals another way to get claims paid. But the statute says you have this internal review process now.
Which provision precisely are you relying on?
Sure. Insurance law 4904 requires insurers like Fidelis to have
Which
this process.
subsection of 4904? There are plenty.
Well, the 4904, yeah, you're right.
Which particular subsection are you relying
Entire
on?
subsection. It has all the requirements about what you must have in the plan. But the key provision is 4907.
Wait. Tell me about 49, before you jump to 4907, since you said 4904 is the gospel, what section in 4904 should I be looking at that you are relying on?
I'm relying on 4907. 4904 is what puts, that's a non-controversial question. 4904 has a...
Oh, so you mentioned it for no reason. Go ahead,
I did.
4907, tell me.
4904 are the provisions that require the insurers to have an internal review, and then 4907, or excuse me, 4906 subsection A.
Yeah, because 4907 is one sentence. Go ahead.
Actually, I misspoke. 4907.
This is
The
a moving
one-
target here.
I know it is. I meant to say. There's 3 provisions, Your Honor. 4904 requires the internal
Again,
review.
4904 has multiple provisions, so which language are you relying? Counsel, I've got the sections right in front of me. So I'd like to be able to follow with you as you argue, which is why I keep on interrupting you, so forgive me, but I'm trying to follow your argument. So tell me what provision in particular you are relying on so that I can cue into that language.
4907 has.
I thought you went back to
I'm
4904.
sorry, I misspoke. The numbers are killing me.
This is like who's on first.
Yeah. 4904, all of the provisions are applicable. It has
Nice.
the different components.
Nice.
That,
Okay.
so 4904.
I got 3 pages, all of them. Go ahead.
Those are the requirements that the plan must meet. Now, the one sentence in 4907 says as follows. I'm going to quote it. It's one sentence. Quote, "The rights and remedies conferred in this article upon insureds and healthcare providers shall be cumulative." And in
Counsel,
addition,
unless, that tells me nothing. That sentence tells me nothing unless you tell me what particular section in 4904, subsection what, you are relying on. Let's not play this game, the whole statute. You're relying on particular language. What is it?
it's 4904B requires the utilization review agent to establish the process for appeals, internal appeals. C requires establishment of standard appeals.
And what was
those-
violated?
What was violated,
Right, so it
4905
sets out
4907 was violated.
No,
Because they put-
4907 is a one-sentence catch-all,
Yeah.
okay?
Okay.
So that's, counsel, I really am trying to get at the heart of your argument.
I
I'm not-
understand that.
I am not trying to beat you up.
I
am
know that.
trying to get to the heart of your argument.
Okay, here's the heart of the argument.
Go ahead.
And both sides agree that on this. Fidelis is required to have a compliant 4904 internal review process. That's uncontested. Here's the dispute. Fidelis is saying that we can require you to go through that process, and if you don't go through that, you can't come to court.
And what in any of these sections controverts what they say?
4907.
Nope, sorry.
It says right there that the rights that are given to you under this statute are in lieu of and in addition to your right to go to court. And this court addressed that in the Schulman case. The Schulman case, which found the identical language to 4907, ruled it implements the legislative intent that hospital providers be given an additional tool to get claims reviewed and paid. This is an exact.
Does that mean that the hospital gets to ignore the internal policy of an insurance company's claim procedure? What you just
Yes,
said,
absolutely.
they can ignore it.
It's an option. They could either go for
No,
an
it
internal
said
review or go to
additional.
court.
The plain meaning of additional means another thing, right? Well, you
Correct.
did not even go through the first layer of the internal review through the insurance company.
We're not required to. We have the option of going. through the-
That's not, additional doesn't mean optional. They're two different words.
Addition
says
means
community-
and,
More.
not or.
Well, I'll use the
Optional
word
is or.
option in this court's decision in Schulman.
Additional means and, not or.
It says not in lieu of.
So
It says additional and not in lieu of present rights. 7904 says any rights that you get for an internal review are cumulative and in addition to, and not in lieu of, any rights or remedies available under law. What this court found and what that language plainly says is that you have something you can do as an optional tool. You can choose every time you get a denial to go to court or go to the internal review process. That's why.
So then what would be the effect of having an internal review process within a contract if you never have to abide by it at any time?
It's a statute to benefit hospitals, that if they prefer not to go to court, they could go try to get paid this way, and if that doesn't work, then go to court. The whole idea is to try.
Is your friend correct that you've done it, the eternal process, for the last 25 years?
Not exclusively, yeah, but sure. We take a lot of them through internal review because it's cheaper, and sometimes we go to court. That's what the law says.
Okay, thank you. We've got your argument.
Just one short point, Your Honors, on the Shulman case. I just want to point out that the Shulman case is about external appeals. It's an apples and oranges comparison. That entire citation, all the cases that the hospital relies on are about the external appeal not replacing judicial review, not replacing arbitration or a lawsuit. It's just another avenue, another forum that you can raise your dispute in. What we're talking about is the internal appeal as a prerequisite to a lawsuit or an arbitration. Apples and oranges. Thank you, Your Honor.
Thank you. People versus Angel Figaroa. You may proceed.
Good afternoon, Your Honors. My name is Thomas Palumbo of the Legal Aid Society, and I'm here today on behalf of Mr. Angel Figaroa. When Mr. Figaroa pled guilty in the lower court, he was not apprised of all of his Boykin rights, the constitutional rights that he was waiving by pleading guilty and not going to trial. This means that Mr. Figaroa did not enter a knowing, intelligent, and voluntary plea. So today, we're asking this court to vacate this plea, and as Mr. Figaroa has already served his prison sentence and several years of his post-release supervision, we're asking that the court dismiss the accusatory instrument against Mr. Figaroa in the interest of justice. And in the alternative, we would...
What was defective?
So, Your Honor, there are 3 Boykin rights, as they're known, that the court needs to tell Mr. Figueroa his...
And he gave him 2 out of the 3, correct?
I would say, Your Honor, he gave 1 unquestionably. He said that the court told Mr. Figueroa that he was giving up his right to question witnesses against him. That was unquestioned. But there is no point where the judge tells Mr. Figueroa that he is giving, that he has...
The court said that he's giving up his right to a trial. I thought that your argument was that the court left out the word jury.
Yes, Your Honor. And previous case law, including Suazo, says that there's a significant difference between saying jury trial and just...
Well, putting that aside, was this argument preserved before the trial court?
Yes, Your Honor. In this case, we can reach this issue because either in the interest of justice, as this court
No. The question was it preserved? We know if it's not preserved, we can reach it in the interest of justice. But the answer to my colleague's question is no, right?
That's correct, Your Honor. So this was not raised by Mr. Figueroa, so it was not preserved in that way. But as this court has done before, it can still reach this argument, as it has in Pearson, on a Boykin case in the interest of justice.
Now,
And
if
we
I
were to
may,
do that- I'm sorry, go ahead.
if I may, the guilty plea was October 27th, 2015, right?
That's right, Your Honor.
All right. And then the sentence was December 3rd of the same year.
That's right, Your Honor.
So it's fair to say that there was an opportunity, I mean, a month and some, but for whatever reason, decided not to move to withdraw the plea.
I hear you on that, Your Honor. And what I would just say is, even though I can't speak to why that issue was not raised in between the plea and the sentence, but what I can say is when we're looking at this in the interest of justice, in the totality of the circumstances, this is a case where Mr. Figueroa was not apprised of his constitutional rights. And this court has found, and other courts within...
Counsel, let me jump in here. So under Contestant, the court has previously held that a guilty plea isn't invalid solely because a trial court failed to recite a defendant's constitutional rights under Boykin, right? And then under Pellegrino, the court said that the record as a whole, however, must affirmatively demonstrate the defendant knowingly, intelligently, and voluntarily waived those rights. So here, where defendant confirmed that he spoke with counsel, no one forced him to plead guilty, no one made promises. He understood that because he was on parole, that the conviction could result in a parole violation and more time. What part is missing? The word jury? You're hanging everything on the word jury trial?
No, Your Honor. There's both the jury trial, and there was no point where the judge told Mr. Figaroa that he had the right to remain silent. In fact, he actually says you'd be giving up your right to tell your side of the story. So there's both one entire right missing as well as the crucial word jury.
And this plea was accompanied by a written waiver?
I'm not sure that that's on the record, Your Honor, if everything in the plea was specifically given to him in a written waiver. But what I can say specifically is that when...
Are there any pleas where a waiver is taken that a written waiver is not required and signed in front of the judge?
I would expect not, Your Honor, but what I can say is there's nothing in the record of this case to show that Mr. Figaroa was apprised of his Boykin rights.
Thank you. Have a good day.
Good afternoon, Your Honors. Eddie Mallory Phelps for the people.
So, counsel, your adversary says essentially that the defendant received 1.5 of his Boykin rights, and that invalidates his plea. What do you have to say?
I would argue that the defendant was informed of 2 of his 3 Boykin rights. As my colleague admits, one of them was clearly given, and as this court has previously found, just not mentioning the word jury when describing the right to a jury trial is not enough to disqualify Boykin rights not being properly given.
Counsel, let's say that we utilize our interest of justice power. Was this sentence excessive?
I don't think so, Your Honor. He got the minimum sentence for incarceration, which he's already served, and he got a mid-range sentence, 5 lower than the maximum for his post-supervised release. Additionally, this is a fairly serious crime. It's his second
That he committed while on parole.
that he committed on parole and under SORA already.
Under what, I'm sorry?
SORA level 2.
Okay. He had a previous conviction for rape, right?
Correct. In Brooklyn, rape in the first degree.
And what degree was that?
First degree rape.
So he had a rape one prior, and this is also a rape one.
This is not a rape one.
This is not a rape one?
This is sexual abuse.
Sex abuse.
I'm sorry. You're
But
right.
yes, correct.
Sexual,
He had
sexual abuse one.
yes. He also had first degree rape from Brooklyn. While he was on parole for that and was under second degree for SORA, this is when this crime was committed.
Right, so in his position as a janitor supervisor, apparently, he decides to utilize that position to sexually abuse applicants for a job.
Correct. First, he tried to pressure her like a quid pro quo, and when that didn't work, he physically forced her.
Right. You have anything
If you have
else?
no further questions.
Thank you.
Thank you, Your Honor.
Counsel?
Counsel, I'm going to pose the same question to you. How is this sentence excessive?
Your Honor, I think that it's important to note Mr. Figaroa's background in this. No one is contending that
Counsel,
what
but his background is a conviction for rape one.
Yes, Your Honor, and no one is...
And while on parole for that, he does this to this woman who just wants a job.
No one is contending what Mr. Figueroa did is not serious. He has taken full responsibility and shown deep remorse.
So how is 5 years and 10 years post-release supervision excessive?
Seeing as the parole conditions didn't prevent him from committing this crime.
Yes, Your Honors, and in between, since the first crime and now this crime, Mr. Figueroa has, for the first time, opened up about the sexual abuse that he experienced as a child and talked about how...
You know, and if that's true, I'm sorry for him, but there are thousands and thousands of people in this country who have been subjected to sexual abuse who don't sexually abuse.
Absolutely,
So
Your Honor.
that doesn't give him a free ride.
No, Your Honor, and he's not asking for a free ride here. What he's asking for is the fact that he's acknowledged that this behavior is unacceptable. He has said that he didn't fully understand it, and he is working to better himself. And that is something that is different between what happened in between the first, his first conviction and now
All
after
that
this
says is that the rehabilitation has worked.
Well, yes, Your Honor. So I would say that he is now in a much better position. He has served his full incarceratory sentence and has now served several years of post-release supervision.
He wants us to shorten that.
Yes, Your Honor. So he is served about 3 years of the post-release supervision. This would be shortening it to 5 years as opposed to 10.
And how long was he out on parole before he committed this crime?
In that case, I believe it was 3 years, Your Honor.
Ah, so about the same amount of time before he committed the last crime and got the itch to do something else. He wants us to lift the supervision over him and hope and pray that he's good now.
Your Honor, just in closing, I would say that this excessive sentence is one avenue, but again, we highlight that he was not apprised of his constitutional rights, and we ask that you vacate the plea on the Boykin grounds.
Thank you.
Thank you, Your Honor.
All right, Wilmington Savings versus AmTrust Title.
Good afternoon, Your Honors. May it please the Court, Eric Mandel for the Plaintiff Appellant, Wilmington Savings Fund. Your Honors, there is a surprising absence of case law involving the issues on this appeal.
Counsel, I would beg to differ. Court of Appeals in Plotch in 2016 said in the absence of a lien, the consolidation of two mortgages into a single mortgage equals the first mortgage of record. So, and I don't get it. I don't see why you say there's a dearth of law. And even if you look at the second department, a title insurer's liability to the insured is based on contract law and limited by the terms of the title insurance policy. Here, the condition 2 of the AmTrust policy said that the policy remained in effect only so long as the insured, and this would be the Rosa mortgage, retains an estate or interest in the land. At the point where you have a consolidation of the two mortgages, the Gap mortgage and the Rosa mortgage, Rosa disappears.
Your Honor.
Subsumed.
I would respond.
Better word than mine.
Well, Your Honors, the plain language of the policy defines the term insured as the owner of the indebtedness or the successor of the indebtedness, which means the assignee. In this case, the underlying mortgage that was insured by AmTrust was assigned and not satisfied, which was the basis of the claim denial.
It was subsumed by the consolidated mortgages, so it no longer exists.
There is case law that says that where a first mortgage is assigned, and I've cited it in the brief, that where a first mortgage is assigned and consolidated with a new consolidated mortgage, that first mortgage retains its independent lien status. There's nothing within this policy that says when a mortgage is assigned and consolidated with
When
the
this
subsequent...
consolidation took place, there was a new insurance policy on the new $3 million consolidated mortgage, no?
There was.
Okay, so why are we here? Why, if you have already an insurance on the entire note, why is your client trying to access insurance for the same amount? You cannot get more than the $3 million that is already there.
No, we are asking that two policies of insurance be put in, that two
But they
policies...
have to be active, and they weren't after the consolidation.
There is nothing in this policy at this point, on a pre-answer motion to dismiss, there is nothing in this policy that
Except
says
the language of the policy?
No, in section 10B, it says liability under this policy terminates upon a satisfaction. It does not say upon an assignment. And if there's any ambiguity within the policy, it is construed against the insurance company. The term
Counsel,
insured specifically...
You mentioned the case law that you cited. However, the case law that you cited, they're distinguishable from this case because those cases didn't involve consolidated mortgages.
I believe Benson did involve a consolidated
Not one of
mortgage.
your cases involved a consolidated mortgage.
Your Honors, there...
Not one of them. We read all of them.
The holding in that, if I may...
The holding has to apply to the facts that are similar to this case.
There is no...
And there was not a consolidated mortgage in the cases you cited.
There is no case on point. In this, in this state,
And there lies the rub, right?
if I
So
may,
you want us to, what you want us to do is take those cases that had nothing to do with a consolidated mortgage and apply that holding to this case. That's what you'd like us to do.
that is what I'd like the court to
Yeah.
do. And if I may, to adopt the defendant's position would result in a determination that every time a mortgage is assigned and consolidated, the prior title policy terminates. There
It depends on the language of the title policy.
And in this case, it only terminates upon a satisfaction and not an assignment.
Okay, let's go to the language. Let's just cut to the chase here. Let's go to Section 2A of the agreement to combine notes and mortgages. Under the law, the lender has one mortgage and borrower has one loan obligation. And we'll skip Section 3. Consolidated note will supersede all terms, covenants, and provisions of the mortgages. Section 4. The consolidated mortgages will supersede all terms, covenants, and provisions of the mortgages. Also, Section 4, the consolidated mortgage serves as a consolidated note and will constitute in law a single lien on the property.
I don't disagree with any of that, Your
So
Honor.
then why are we here?
But I do look at the four corners of the document, and there is nothing in the title policy that says that it terminates upon an assignment and a consolidation.
Except that language. You'll have time on rebuttal.
Afternoon, Your Honors. Jeffrey Metz for the respondent. Your Honors, I'll rest on my brief unless the court has any.
Smart man.
Very smart, very, very smart.
Thank you. You have 1 minute.
I would like to refer the court, if I may, to the title policy, Section 1EC, which says that the term insured, in addition to being a successor in ownership, says a successor to an insured by dissolution, merger, consolidation, distribution, or reorganization. Now, whether that means in terms of a business dissolving or being consolidated with another business, that's an issue of intent. This was a pre-answer motion to dismiss. That language alone creates an issue as to whether an insured remains an insured despite a subsequent consolidation.
Thank you. Cuomo versus James. Let me get the clock. You may proceed.
Good afternoon, Matthew Grieco, on behalf of the Office of the Attorney General. The court below did not have authority to direct in-camera review of OAG's redactions. This court should reverse the orders appealed from and dismiss the petition. An administrative appeal of the redactions prior to in-camera review is both a statutory requirement and a practical necessity. The appeal from the redactions is where the agency will set forth the legal reasoning for its decision.
Counsel, did you constructively deny this request?
The request has not been constructively denied.
Has it been denied at all?
It has not been denied at all. That is correct.
Have you submitted productions of documents?
That is correct, yes.
At least 5, correct?
There have now been 6, and the 7th will be in March.
December was the 6th,
That's correct.
and the 7th will be in March.
That is correct, March 24th.
Therefore, production of the documents is continuing,
That is correct.
and there's been no review of those productions internally.
There has not yet been an administrative appeal from the Records Access Officer to the FOIL Appeals Officer, which is required both by the FOIL statute and by General Article 78 principles before there can be judicial review of OAG's redactions.
Has there been a formal denial?
What's that?
Has there been a formal denial?
There has not.
Thank you.
Absent the opinion letter, the reviewing court, from the opinion letter from the FOIL Appeals Officer, the reviewing court does not have the requisite explanation for any denial of access to records and cannot perform a meaningful review. Every claim in this Article 78 petition is...
Counsel, you got to slow down,
I
please.
apologize, Your Honor.
Remember that I said that if the court has more questions, you will be allowed to keep talking. So I want to understand what you're saying, okay? So
Certainly, Your
okay?
Honor.
All right.
As I was saying, every claim in the Article 78 petition is either premature or moot. The only claim that petitioner has administratively exhausted...
Counsel, There's no train behind you. Slow down.
I apologize. It's my,
Counsel,
it's
let
my
me
normal
ask you a
speaking
question. A
speed. As anyone
request-
who knows me can tell you, it's not for the court, and I will try to slow down.
Counsel, let me stop you for
Yes.
a little bit, because I'm like you a little bit.
Yeah.
Get excited and I talk quickly. They made a request.
Yes,
5 days later, you responded and said, give us time, we will respond by August 30th, correct?
correct.
On August 30th, you responded and you said, we will start producing to you by March 1st, correct?
That is correct.
No constructive denial,
Correct.
no formal denial.
Correct.
There you go. Go
Counsel, in their petition, they also alleged that there was actual denial. Do you have any idea what they are talking about when they say actual denial, what that's based on?
So at the time the petition was filed, there's nothing nothing cogent that could have referred to, because they filed the Article 78 petition before the promised date of the start of production. So it certainly couldn't refer to redactions, because the redactions had not yet been released. So it's that claim in the petition is, it's not attached to anything.
They claim that on previous occasions when you produced items that were redacted, and so they could anticipate that you would do the same thing with their request, with their request.
Whether they anticipated redactions or not, the fact is that they have to appeal the redactions themselves administratively to the FOIL appeals officer before there can be judicial review of
Well,
that.
they argue it would have been futile because you weren't going to give it to them anyway.
Well, two points on that, Your Honor. Number one, it happens all the time that at OAG and other agencies, that when you appeal redactions, or when you appeal a partial withholding or partial denial, that the FOIL appeals officer, in some cases they may grant the whole appeal. In other cases they may say, okay, these redactions remain in place, but I'm going to lift these redactions. So to the extent that some redactions could be lifted upon a thorough review by the FOIL appeals officer, that's not futile. And the other reason that it isn't futile, and the reason that the statute and the case law requires an administrative appeal of the redactions, is that there's no substantive legal reasoning for this court or the court below to review in camera or otherwise prior to the conclusion of an administrative appeal.
Here's a question. To the extent that the Article 78 was filed in January of 2024 and the production of documents was scheduled to begin in March of 2024, is this a classic ABC case of failure to exhaust administrative remedies?
It is, and in addition to that, the point that I was going to make earlier is that the only claim that the petitioner administratively exhausted on appeal, and the only one that is...
Slow down.
Please.
Slow down.
The only one that is set forth in the Article 78 petition is the argument that the March 1st, 2024 date to begin production, in their view, was too far off. That claim became moot when the production actually began, and there's been no...
Because they wanted you to drop all the other prior foils and just focus on this.
Right, and as the Court of Appeals made clear in the Daily Gazette versus City of Schenectady case, all FOIL requests are to be treated
Counsel,
equally.
they're not pulling it out of, I guess, the thin air that the request was going to be denied. They rely on a denial to the Daily News for FOILable information as part of their reasoning for.
So a couple of points on that. The denial by the Daily News, first of all, was never administratively appealed. Secondly, in addition to that...
Do we have anything on the record on that?
I'm sorry?
Do we have anything on our record on that, or is that?
Well, that was from a different case, but...
So it's DeHore's the record?
That is correct, yes.
Correct.
Right, so
Counsel,
everything about the Daily News
Can I
is-
just inquire about one other thing? There was a mention regarding interview notes, that interview notes were not being turned over and have not been turned over. Is that the case? Have the interview notes been redacted yet turned over as part of the information handed over?
So that part of the production has not yet been reached. When OAG receives a large FOIL request, such as this one,
Is this the only request that the AG's appeals office, FOIL officer has?
No, she
Does the FOIL officer for the AG's office receive requests from multiple people throughout the state every day, throughout the year?
Yes, there's approximately 1,000 a year, about 3 or 4 a day.
Okay.
coming in.
So when you received this one, were there no requests pending before the AG's office that they could dedicate all of their resources just to this request?
That would not have been feasible, Your Honor.
I didn't think so. Thank you.
Good afternoon. Rita Glavin for Andrew Cuomo. Number one, the request was constructively denied. I want to pivot to your first point. The August 30th letter responding to Governor Cuomo's initial FOIL request did not provide a date certain, which is required under 83A. What that request said?
They said March
They said we
1st.
will start producing responsive records by March 1st, 2024.
And on that date, they actually did start producing records.
They
So-
produced 9 transcripts, Your Honor, which was basically the redacted transcripts that the Attorney General's office had already released 2 years earlier. What is happening here, and I'm going to give you 3 cases, which tells you.
So counsel, when I talk to you, if I talk to you like this, it's
Yeah.
disrespect. So let's not go there.
I'm sorry, I don't
right?
mean it that way.
Thank you.
You did, but go ahead.
I didn't mean it that way. All right. One, with respect to the constructive denial, what the Attorney General's office has done is they have been in 2 different federal court proceedings, and they have told 2 different federal courts in the Eastern and Southern District when Governor Cuomo has asked for these exact records. There are 2 parts to them. There are the witness interview memos, which have already been redacted for attorney-client and attorney work product privilege.
As to those 2 plaintiffs? On those 2 cases?
Not with respect to
On
this.
all 179 interviews?
There's actually 155, and yes, they've already been redacted. Cleary Gottlieb redacted those memos. They are sitting.
But those redactions were in connection with a different type of action.
No. Actually, no, they were not. They were done before, I think before we subpoenaed them. And the 2 privileges that they redacted the memos for apply to the FOIL proceedings. It was attorney-client and attorney work
But the
product
way that
privileges.
you would determine to redact it from that perspective is different from how you would make a determination to redact something that's foilable.
Absolutely not, Your Honor, because the privileges they are seeking with respect to the interview memos are attorney-client and attorney work product privilege.
And privacy as well?
I don't know that there are any privacy interests. We have
So
got-
counsel,
Yes.
how are we supposed to know if we don't have a final decision from the AG's office?
But the problem that you have here is that if you agree with the Attorney General's office position that we can produce, okay, on a rolling basis. So this FOIL request was made in July of 2023. We are now coming up on 2 years. I urge you to look at the Friedman case before the New York State Court of Appeals, the Data Tree case before the New York State Court of Appeals, and this court's case in New York Times versus NYPD. In those cases, there were constructive denials. Court of Appeals and this court sent it back to Supreme Court to make a determination at that point about
But
redactions.
we would have to find that there was a constructive denial in that letter.
And the Supreme Court did.
We'd have to agree.
You would have to agree. But if you agree with the Attorney General's position in this case, the precedent that you will set for every New Yorker who makes a request of any state agency going forward under FOIL.
Does every New Yorker get to expect that they get to jump the line on their request?
Absolutely not, Your Honor.
Okay,
And
so how long is reasonable to review 179 interviews, 179 memorandums? How long
Your Honor,
should they have?
not years.
Should they have to hire additional staff in order to do this?
Your Honor, the Attorney General's office has already stated both their FOIL officer, in this case, Catherine Scheingold, she told the New York Daily News in response to the same FOIL request for the interview memos, they were entirely protected by attorney-client and work product privilege. Not
So
only
are
that,
you saying that the Daily News FOIL request was exactly the same as Mr. Cuomo's?
yes. In what,
You know, you need to let me, you really need to let me finish. You're saying it's the same exact request, that it was duplicative?
there were, actually, no.
There's no
They asked for the
distinction?
memos.
Okay.
They asked for the interview memos, and they were
And
denied.
what else did, And what else did Mr. Cuomo's FOIL request entail?
The unredacted transcripts, two parts.
Unredacted transcripts of how many witnesses?
41.
41, who all have privacy concerns. So with respect to what you're saying as to a New Yorker having to wait to have their FOIL requests responded to, isn't the other side of the equation the people who made the complaints, the people who had any information about the sexual harassment claims also have privacy concerns?
Yes, and the 41 transcripts were already redacted for exactly that, which is what the
redactions were done under a different context.
No, the redactions were done, and the Attorney General's office has said this. They were done for privacy reasons. Those were the transcripts that were released. What we have been getting from the Attorney General's office is basically what they already publicly released. And as we sit here today,
I have a problem with basically what they already released. We don't know the final outcome. There's been no review. The production is underway as we speak. It's not finished.
And we don't have a determination to look at to say whether, in fact, this determination was arbitrary or whether other redactions should have not been made. We don't have any of that.
But you do with respect to the interview memos, because the Attorney General's...
So we should look at it piecemeal and not look at the entire FOILable request?
No, there's two parts to the FOIL request. There's very specific documents. On our cross appeal, what we're arguing is that the interview memos should be directed to be produced to Justice Boyne to go back, because the Attorney General's office has already stated to another FOIL litigant, and it was administratively appealed. It is at pages 732 to 738 in the record. New York Daily News administratively appealed it. It was denied in its entirety on attorney-client privilege and work product grounds. That is what they're claiming over them. So for us to go back, when you say exhaust administrative remedies, where it would be futile, where the Attorney General's office is already repeatedly saying that they are asserting over the entirety of those memos, attorney-client and attorney-work product privilege, to go back to the administrative agency is exactly what Justice Rivera said in the majority opinion in Friedman, which is what she said is that the exhaustion, the administrative exhaustion requirement is not an inflexible one. And when it would result in judicial resources and having to come back and do Article 78s over and over again.
It's interesting, seeing as we've been reversed on Article 78s where we overturn them. So interesting, by the very judge you've just quoted. But you'll have time on rebuttal.
Thank you.
So, counsel, your adversary says that basically you're wasting their time and making them wait unnecessarily because you really have constructively denied their FOIL request.
Well, I want to address a couple of points about that. First of all, I would not agree with my friend that the court below found a constructive denial. In the June decision, the court made quite clear that it was finding an actual denial as to 9 specific transcripts, and that otherwise it was dismissing the petition entirely. And there was not, and the court actually said that this is not a finding of constructive denial. It's a finding of actual denial. I also want to point out that at pages 2981 and 2982 of the record, the court actually said that the production timeline has not been unreasonable under the attendant circumstances, which is the standard. Where the court then erred, and it's actually on the same pages of the record, 2981 and 2982, was to say that even though it was reasonable that given public interest in this particular FOIL request, that OAG ought to have sort of moved this, as one of your honors alluded to, sort of jumped the line and moved it ahead. And that is flatly wrong under the spirit of FOIL and under settled law. Under the Daily Gazette versus City of Schenectady case, the court made clear that an agency not only need not, but must not give any consideration to the status, the motive for the request, or the alleged degree of need for the documents. The way that the public interest is served under FOIL is by treating all FOIL requesters equally, and by ensuring that the requirements in FOIL, including the requirement to redact for to prevent unwarranted invasions
Counsel,
of personal privacy.
The
are followed.
language in the letter regarding the response, did that language trigger a date certain response?
I'm sorry, the language in which letter?
The language in the letter where it's indicated that the AG's office would look at the records and acknowledge it and turn over materials by March 1st. Does that language trigger a date certain?
Well, the March 1st is the date certain.
Okay.
Is the date certain that is required by the statute. It's the date when the production would.
I want you to address your adversary's arguments that much of the review has already happened. And so the amount of time that is being taken, look, I don't begrudge the office the right to look through it again on this request and make determinations on this request. But having done it once before, that second time around should be a lot faster. So explain to me why she is not correct, that this is taking an inordinate amount of time, and if they have to wait on a rolling basis to wait for all 41, what year will we be in before it is right for them to bring an Article 78 to determine whether the decisions being made by the FOIL officer are correct or not?
So there's three reasons why my friend's argument on that point is not correct. The first, as Justice Michael alluded to earlier with one of her questions, is that the FOIL has its own standards for requiring redaction to prevent unwarranted invasions of personal privacy that are separate apart from any other legal requirement. The second reason is that in performing this review, the records access officer is providing a service to the requester by looking to see whether there are things that have previously been redacted that can now be unredacted. And so the thorough review is to the benefit of the person making the request. And the third reason for
like I said, I don't begrudge you looking at them again, but why is it taking so long?
Well, it's extremely voluminous. I mean, to date, we've produced a little bit over 5,500 pages of transcript.
What about what your adversary said, that they were the same redacted documents that were already produced? So there was really nothing different in what was provided.
Well, and there's a citation in our brief, there are also documents that contain less redactions than were previously released. And the purpose of the detailed review is to see what can be released. And the third and final reason that the review is extensive, in addition to the lengthy number of pages and the extensive review required, is that it has to be performed individually by the records access officer, unlike prior reviews which were done by a large team. And statements that may appear innocuous on the page by themselves may contain a reference to something that is protected elsewhere in that same interview or in a different deposition, which is why it needs to be performed by the records access officer individually and then administratively appealed to the FOIL access officer before there can be judicial review.
With respect to the prior redactions based on attorney-client privilege, are those the equivalent of review to redact where privilege concerns need to be addressed?
I'm not sure I understand the question. I'm sorry, Your Honor.
So is there a difference between a review for privacy and a review for attorney-client privilege?
Oh, yes, there is. Yes.
And what is that?
The difference is that the review for personal privacy is that because the nature of the investigation is a sexual harassment investigation, and all the documents pertain to an investigation into that topic, there has to be careful review to ensure that any documents released do not have an unwarranted invasion of personal privacy.
Has the Attorney General's office maintained at any point that the 41 interviews were conducted with people who are the Attorney General's clients, and therefore that those fall under the attorney-client?
Or employees.
Or employees.
I don't know the answer to that question, Your Honor.
Okay.
Your Honors, I want to hit on the interview memos. I'm sorry, it's my habit of talking. I'm sorry. I want to hit on the interview memos. The Attorney General's office is claiming attorney-client privilege over the entirety of those memos. So it's not a matter of redactions. It's over the entirety of those. It is over the
But
entirety
we have
of those
transcripts, we have videos, we have interview notes and memoranda. They're all different.
No, it's come down to two categories, and we made this clear before.
Just
It is just the transcripts, and it's just the interview memos. There are approximately 155 interview memos. Those memos, the entirety of them, the Attorney General's office, it's not a matter of giving them piecemeal, they have asserted attorney-client and work product privilege over the entirety of them, which is why we have raised in our brief.
Is that in what page in the record?
Oh, it's in, look at the FOIL denial to the New York Daily News. It's at 732.
We're talking about
Yeah,
the
but
Daily News
see,
again.
to me, I'm sorry. The denial to Daily News is a separate issue. And I am not going, to me, that's not apples and apples. It's not apples and apples. We have a news agency wanting access to all this stuff, and we have a person who was personally affected by this investigation. To me, that's different. To me, your client, to me, has more right and more access, more entitlement to this information. He was the one who was personally impacted by it. So I don't see it as the same. I can see how there would be things that they would say, no, the Daily News ain't getting that, and we're gonna see them print the whole list of everybody, every witness's name and address on the front page of the Daily News, versus someone who is right, who is contesting
Counsel,
what happened.
are you essentially saying that because they're claiming attorney-client work product, that it'll be attorney-client work product regardless of the person requesting it?
Yes, they're saying that across the board. And so what's really important, because I do want to hit on the interview memos and it's in our brief, what's really important is that in both proceedings, before the federal case, before Bennett and the Draper 1 case, when we subpoenaed those memos, the Attorney General's office, and it was the highest levels, it was the Deputy Counsel of the Attorney General, said, we will never give the interview memos. They are protected by attorney-client and work product privilege. For that reason, and I get, you want people to exhaust. But in cases like this,
That's why you argued it was futile.
Well, but we can't say necessarily that it's futile because that wasn't told to you. And as my colleague said, your client stands in a different position from the Daily News.
It's been told to me in the Eastern District by the Attorney General.
That was in a different context.
You know the frustration here, counsel?
I'm getting
is that the frustration, and speaking only for myself, is all this time that has passed, right?
Yeah.
That perhaps had your side waited until that first production and then hit us with an Article 78 based on that production, you might have a stronger leg. We're being asked to make decisions on an important issue based on summary conclusions on both sides, right? So I'm not just saying you, I'm both sides. Oh, it's this, it's that. And I have no record. I have nothing to say, we are keeping this because X, Y, and Z. And then have your side say, well, that's ridiculous because of A, B, and C, right? That's typically how we resolve these.
You have such a record in this case of the very agency saying all of these interview memos are protected by attorney-client privilege. The only reason we're here and that we had to go through the FOIL process is because when we subpoenaed the Attorney General's office for the memos, their first position was you can't subpoena us in federal court because we're immune from federal subpoenas. And therefore, this is how we ended up in FOIL.
Well, then they also said that the subpoena was overbroad, right?
And then we narrowed the subpoenas to focus just on, so in the first place, yes, the judge said it was overbroad, but then we narrowed it, and all that's at issue right now is unredacted transcripts and the interview memos. And I think with the interview memos, which is the subject of our cross appeal, the record, and we cite it in our briefs, how many more times can the Attorney General's office tell us the memos
Well, they
are
didn't
privileged?
tell you. They said it in a different context.
They told us this. The attorney-client privilege doesn't change in FOIL or in
Well,
federal
in
court.
order for
It's the
us to be able to make a determination, we have to have that said or that statement made in a context that we can adjudicate. We can't adjudicate it in a context of a federal case that you were told you weren't getting it.
You can take judicial notice of it, that this is the actual agency. I urge you before we go, okay? I'm listening. 3 cases. Look at the Friedman case, look at the Data Tree case, the 2 Court of Appeals cases, and then look at this court's case in New York Times versus NYPD. Data Tree and New York Times versus NYPD were constructive denial cases, and they went back straight to Supreme. They did not say to them, you need to go through and exhaust administrative processes, including on redactions. But please look at those cases, because all of the cases that are cited by the Attorney General's office does not have what we have here, which is an agency that has said repeatedly the entirety of these memos are privileged and we're never going to give them over absent a court order. We've had that said repeatedly. We also had it said to another FOIL requester. And actually, there was a second FOIL request.
No, but you see,
You've never had that before.
I cannot make my decision based on what was said to another party on another case.
Look at the
I'm sorry.
It wasn't said to another party. It was said to Governor Cuomo. It's the same person in every one of these cases. Because the reality of what's happening here, no bones about it, it's being dragged out deliberately. They know they're never going to give us the interview memos. They can't say it any
The
louder.
problem with the cases that you cite,
And if we don't ever go to a hearing, the court won't ever be able to substantively address the issue.
Which is why you should send it back to Justice Moyne.
the problem with the cases that you cite, it was clear in paperwork on that case or in a letter relating to that case or in a brief that the documents would never be turned over. We don't have that in this case. We don't have anything from the Attorney General's office in the context of this litigation on this case that they never intend to turn over those documents.
And that is why it is a denial. We are here now almost 2 years later and not a single interview memo has been
No, it's not a denial. The question then turns on whether in fact they've had a reasonable amount of time to gather, inspect, and review the materials and turn them over.
They don't need to on the interview memos because they have said that they are privileged. It's not, the position isn't going to change.
Yeah, it's okay, because
We're talking in circles.
I get it, we're gonna go around in circles but I understand your argument and I thank you. Counsel, you have 2 minutes.
Thank you.
Thank you.
Oh, I get another rebuttal? A second rebuttal?
No.
We're done?
Yeah, I think I've
Okay,
already done
we're
rebuttal.
done.
Yeah, okay.
Thank you. It's been going on so long, I've lost track. Thank you both. Have a good day.
Thank you.
I like that spirited argument. All right. Abrahami versus Feldman and Meir.
Oh, we had 10, no?
Huh?
Creekstone.
Oh, I'm sorry.
Creekstone.
You know what? Creekstone, I'm sorry. They're here. Let me just get them. Forgive me, ladies, okay? All right. This happens every now and then. All right. 5 minutes. Go ahead.
Good afternoon, Your Honor. Michael Sims for Appellant. We submit that the issues on this appeal are fairly straightforward. We have a case in which you have two elements for ratification, the defendant's knowledge of the transaction and the defendant's retention of the benefits from that transaction. We have the undisputed facts show that the appellant was aware of the allegedly unauthorized loan and guarantee here. That's undisputed. And you have also undisputed that his company received the $30 million loan, and that loan has not been repaid. In fact, this court dealt with the identical issue.
Didn't Feldman say he didn't sign the agreement and that that it was forged?
I thought it was undisputed that it was forged.
Correct.
Well, you just said that it was undisputed that
Undisputed
he was aware.
that he was aware of it subsequently.
You didn't say subsequently before.
That
Okay, so that's why I'm like, I'm sorry, are we reading the right case?
I felt the same way.
Okay, go
well,
ahead.
the knowledge at any point is what's necessary for ratification. Mr. Feldman doesn't need contemporaneous knowledge.
Okay, so
of the
let's talk about
guarantee.
ratification and the $250,000. What do we have in this record that establishes that he was aware that that came from this loan?
The $250,000?
Yes.
Well, we have the record that he took a disbursement from the company the day after the loan proceeds hit the account.
That doesn't mean he knew that that's where it came from.
Well, I would submit that that's not.
I can't assume these people are people who are involved in $30 million deals. So the fact that $250,000 ends up in the account of someone who deals in deals like that is not necessarily unusual.
Right.
That it could have been a disbursement from some other mechanism and not from the forged loan that he didn't even know about the loan.
And did
so
he call his
subsequently-
attorney subsequently to discuss that?
To discuss the loan?
To say, hey, I got this big amount of transaction. I don't recall seeing the loan or the guarantee. I was concerned.
Yes, but that conversation is not relevant to either element of ratification.
There's a lot of questions here, counsel. That's the whole thing.
Right.
Wait,
Who's
before
who's
we move
scamming
on to
whom?
that- Wait.
He
Before
said
we
it wasn't
move on-
relevant.
No. If you ask a question, it's relevant.
Clearly
And if
not.
you think that it's
Our
not
position is,
relevant,
right.
can you tell us why it's your position that it's not relevant?
Right, because our position is that he acquired knowledge about the loan and the guarantee in November of 2020, and Mr. Feldman acquired all the relevant facts. He discussed it with his
Okay,
attorney.
so put that in context with when he received the disbursement and contacted his attorney. Put that in temporal context.
He took a disbursement, the $250,000 disbursement on September 9th, the day after the loan closed.
Exactly. And you said he acquired knowledge in November.
Correct. And therefore, he had knowledge that his company had received this allegedly unauthorized $30 million loan in November of 2020 and made
Does
no effort.
September come before November on the calendar?
No, but there's his knowledge at the time of the transaction or at the time he received the $250,000 disbursement, in our view, is not germane to the issue of whether he subsequently ratified the entire loan. Our position is not that he ratified the $250,000 disbursement.
At the time.
Right. Our position is that he ratified the entirety of the $30 million debt once he became aware of what had happened, and he became fully aware of what had happened in November and December of 2020. His own lawyer, he spoke to his own lawyer. That's referenced in the record. Then his
That's
own
not
lawyer.
relevant, you said. That wasn't relevant. You said that wasn't relevant.
That conversation, he's trying to say. I don't think that's relevant in the context of how the lower court decided it, and that he conducted some investigation, but the investigation was complete as of late November, early December of 2020. His own lawyer sent him a detailed letter, a December 7th letter, it's in the record, outlining the details of the fraud. And Mr. Mayer, the employee who allegedly conducted the fraud, was fired in December of 2020.
When are you saying that ratification occurred? Are you saying it happened over a period of time or in any particular date?
Ratification occurred when Mr. Feldman knew about the transaction and made no attempt and no effort, and to this day has not returned the money, the $30 million that his company received. It's been over 4 years, and there's been no repudiation. In fact, you cannot repudiate the receipt of a note without returning of the money.
Counsel,
how would you repudiate it?
I know that you were going in another direction, and I want to take you back to that direction. When you talked about ratification, I thought that you were going to talk about a case that I sat on.
YHLX, yes.
Yeah, so let's talk about that. That's where I want to go.
I would love to talk about that case.
Wonderful. Why is it that case is applicable here?
Why is that case applicable?
Yes.
Because the facts are the same.
How?
In that-
And let me stop you.
Sure.
So, in that case, there was no investigation at all and no objection at all. I mean, there are other facts, but let's just deal with those two. How is that the same here, in light of the questioning from my colleagues?
Because investigation itself is not an element of ratification. Investigation relates to the knowledge prong of ratification. If you look at the case law, the courts use whether a party investigated. They'll give you a certain amount of time to investigate what happened. And then once that period expires, you're charged with knowledge and the duty to repudiate it. In other words, once you have sufficient time to investigate the facts and learn those facts, once you learn those facts or have had sufficient time to investigate them, you're charged with the duty to repudiate it. Here, it's undisputed that he had knowledge of all the relevant facts concerning this transaction in November and December of 2020 and has never repudiated by returning the money.
Yeah.
And
Well, he never actually got all of the money, right? He got $250,000, but then his unfaithful servant took off with the rest, right?
well, no,
Is there evidence in the record that those $30 million are still in the accounts of your adversary?
there is evidence in the record that there was a disbursement to Mr. Feldman personally. There's evidence in the record that
Are we talking about
That's-
the $250,000?
correct.
Right,
There's evidence in the record
but it's one thing to say, you got $250,000, you should at least give that back, as opposed to the whole $30 million, which he says he never saw.
well, that's his problem as a matter of law. It was his company. He's the only owner of the company. When the money hit his company, he had control and access over that money.
Is there evidence that the money actually hit the company?
Yes, there is.
Okay.
I just want to go back to the prior case,
White
right?
flags,
Because I
yes,
want
Your
to,
Honor.
add some more facts. Now, in that case, Feldman was aware of Meyer's, am I pronouncing the name correctly, Meyer?
Correct.
Okay. His role in negotiating certain transactions. You agree with that, yes?
He was aware of his.
Okay, he was aware. Let's move on.
I
And
think
then,
there's a distinction there,
No,
though.
I'm still speaking.
Yes, Your Honor.
And then, after that, there were even the signatures, right, that he received copies of agreements that Meyer signed, including one with Feldman's signature. That's not what we have here. That's a little different.
That is what we have here. The agreement at issue here is the same, where it bears his stamped signature, which Feldman
forgery
alleges
placed on it.
was forged. Also, with respect to the distinction about Feldman's knowledge in that case, he was aware that Meyer was negotiating some type of transaction. But in the YHLX case, Feldman was not aware that Meyer had forged his signature to the guarantee. In the YHLX case, we were also dealing with a guarantee that Feldman said was unauthorized, for which he was unaware. The same fact here. He's claiming Meyer went out and did it again.
All right.
A guarantee that was forged.
You'll have time on rebuttal. We've gone way over time.
Good afternoon, Your Honors. I'm going to quote Justice Manzanet Daniels from earlier today. A holding has to apply to the facts of the case. That's what you said. Justice Kennedy, you brought up the issue of YHLX. It's not the same. I'll read from your decision. It says, for several months, Feldman had notice of all of the underlying transactions, as well as the default and negotiations to resolve it. He then received actual copies of the allegedly unauthorized agreements signed by Meyer and one bearing his signature, but conducted no investigation and made no objection for the 3 months prior to being sued. Here, completely different. You want to know why? Because they admit it. They acknowledge that, and they define this in their own defined term. They define Mr. Feldman's guarantee as the forged guarantee, capital letters. They not only sued their own counsel for malpractice and obtained millions of dollars in the settlement, but they sued the other lawyers who represented.
Does that have something to do with this case?
It has something to do with the case where they acknowledge the fact that the fraud was so far-reaching to Mr. Feldman, and he had no knowledge of it, that they're suing another law firm, an international law firm, in an arm's-length transaction for fraud. And that case is still before Justice Maisley.
Here's an ABC question.
Sure.
If the guarantee was found to be, if it was nullified because there was a forgery of Mr. Feldman's signature, would he stand to gain by the nullification of the guarantee?
I don't think he would stand to gain by the nullification of the guarantee because by virtue of Mr. Mayer, which again, they acknowledged that there was forgery. They acknowledged that Mr. Feldman disavowed the guarantee in November. And in fact, they acknowledged for the first...
the November communication is relevant.
It's relevant to the extent that with regard to the YH Lex case, which they rely on, it says the YH Lex case says that he conducted no investigation. This one, as soon as he learns about it, they acknowledge that not only did he do everything in his power...
And of course, this happens after that.
It does happen.
So one could argue that your client was on notice about the improper behavior and conduct of his employee.
Well, I don't think that's true, Your Honor, because...
Really?
Yes, in this particular case, Holland and Knight, who basically dealt with the forged signature here, Mr. Feldman was trying to, what this basically did, entering into this forged loan, this fraudulent transaction, it created bad boy liability under another loan when they wrongfully did this loan and encumbered the same assets. That triggered liability. There was also UCC foreclosure sale going on with those same assets they were trying to negotiate. Not only did Mr. Feldman not benefit at all from this transaction, but he ended up losing those substantial properties at the same time. Mr. Mayer hid it from him. Holland and Knight, who was representing Mr. Mayer, and Mr. Mayer pulled the wool over their eyes also, they also did nothing to alert Mr. Feldman. He had no idea this was going on. That's undisputed. That's in the record. They admit that. So to the extent that Mr. Feldman should have known about this, he had no idea about this, and they concede that. So whether he should have known or maybe should have known, the record is clear that he did not. And they concede that. And they concede that his client in November knew about it. They say in page 2 of their brief.
But counsel, this is the $30 million loan that had a guarantee signed, well, ostensibly signed by Mr. Feldman and Mr. Mayer, right?
Correct.
So the two of them.
Correct.
But if it's nullified, it would be nullified as to the two of them, right?
No, Mr. Mayer signed it he knew about it.
So he would still be left dangling?
Yeah, well, Mr. Mayer is currently sitting in Rikers Island because he was indicted at this particular time. So I don't know if that would affect him. He also declared bankruptcy. But also with regard to $30 million.
Can't squeeze blood out of a rock.
No, you cannot. And so they also acknowledge that the $30 million, and someone brought this up. This is in their brief in big, bold letters. Not Mr. Feldman. Mayer converts the Abrahami loan proceeds. So that's at the record at 697. This is also their own words. The undisputed evidence shows Mayer converted the loan proceeds for his own personal uses.
Is there a reason why your client should not return the $250,000 that he was provided by Mr. Mayer improperly?
Well, because they're not seeking $250,000. They're seeking $30 million.
So
that wasn't my question.
Sure. It was never demanded of him to return the $250,000.
Well, let me see. $250,000 falls within the $30 million, no?
It does. Well,
and it would show at least a sign of, I don't know, good faith, right? That my guy did something terrible. You guys are out $30 million, but I received $250. I'm not entitled to. So here, let me give it back.
Well, again, those conversations, there was negotiations that happened before that. To my understanding, that was not acceptable to Mr. Abrahami under these circumstances.
Okay, thank you.
Thank you.
Yes, I would like to quickly jump back to the facts of YH Lex.
You have 1 minute.
Where we had an unauthorized loan and an unauthorized guarantee that Mr. Feldman claimed he did not know about and found out about after the fact. Those are the same facts here. And in that case, this court found that Mr. Feldman ratified the entirety of that debt because he acquired knowledge about the transaction, about the guarantee, and he retained the benefit of it. And his company, in which he's the sole owner, received $30 million. And under the law, he is responsible for the acts of his agent. He should not get to keep the $30 million just because he was negligent in allowing his employee to have access to the accounts and allegedly take the money. I mean, that would set a troubling public policy precedent if the beneficiary of wrongfully received funds could just keep the money and claim, I didn't benefit because somebody took it from me, I lost it, I was negligent with it, and the person who was the defrauded or the victim could never get that money because you would never be able to prove benefit. Here, the funds were indisputably in Mr. Feldman's custody and control through his company. He decided to give Mr. Mayer access to all the accounts of the company, and if the money was lost, that is Mr. Feldman's problem. That as the principal of Mr. Mayer, that is not my client's problem. And Mr. Feldman has made no effort to return any bit of the money. This is not someone who's attempted to repudiate it at all. He never contacted Mr. Abrahami. He received a notice of default, did nothing. Received a demand for payment on the guarantee,
Got it.
did nothing.
Thank you.
Okay, thank you, Your Honor.
Creekstone. Sorry, ladies. You may proceed.
Good afternoon, Your Honors. May it please the court. My name is Gabrielle Siskin, and with leave of this court, I would like to introduce my co-counsel, Kristen Cummings, who has been admitted pro hoc vice to argue on behalf of XL Insurance America, Inc.
And where are you from?
Texas, Your Honor.
Welcome. From
Good
the
afternoon,
big
Your
state of
Honors.
Texas. All right, please proceed.
May it please the court. New York courts have always recognized and upheld the rights of parties to a contract. And while there are certainly exceptions and limitations, there are two rights that have continuously been upheld. And those are the right of parties to agree to the forum in which their dispute will be decided, and the right of parties to agree to the time period in which a lawsuit must be brought for a dispute to be decided. The Supreme Court's order here denying XL's motion to dismiss undermines these fundamental rights.
Talking about the New York Supreme Court?
I'm sorry. Yes, the Supreme Court, the Bronx Supreme Court. I'm so sorry. The order from the Bronx Supreme Court undermines the stability of New York contract law.
How does it undermine the stability of New York contract law?
Especially where in the contract the forum chosen was New York.
Right. And so the provision in the insurance policy includes two parts. One, it says that the parties agree that they will have any dispute decided in the courts of New York. But the second part is that any lawsuit must be commenced within two years. The reason that the parties have that two-part agreement—
And the reason why we didn't get to that 2-year is because of all of the appeals. You kept on appealing every single decision that was being rendered in Louisiana.
Right.
And so you get to run out the clock by doing appeals, and they should be prevented from getting paid on the insurance that they paid for.
Ultimately, the Louisiana Supreme Court said that the forum selection clause in the policy was in fact enforceable. And this is a provision that XL includes in many of its policies to provide that stability and make sure that the
Louisiana went out of its way to make sure that this case stayed alive. They did everything they could to make sure that this case would be decided on the merits.
Yes, Your Honor, but what
So you want us to ignore what the Louisiana court, the Court of Appeals, all of them, all three courts, you want us to ignore that?
No, Your Honor.
Yes,
No,
you
Your
want us to say, you all chose. Your client chose this jurisdiction, right? And so because they stupidly decide to try to file in Louisiana instead of following that provision, you want to take advantage of that and now deny them their day in court totally.
Well, Your Honor, I would say that the parties agreed that the New York would be the forum selection clause. This was something that the parties agreed to do.
Right, but
so we're here, let it go forward.
You're in New York.
But we're here, and we've fought for 8 years about these procedural questions. And so XL has spent time and money just trying to defend—
But the procedural questions that you fought about was because you decided to appeal every decision when in fact the litigation in Louisiana was started within the time frame provided for in your contract, correct?
The reason that XL decided.
Correct? It was filed on time in Louisiana. Although, counsel, you got to answer our questions.
Correct.
Okay.
Right. The Louisiana case was filed 6 months after the date of loss. At that point,
so relatively quickly.
It was. It was after XL paid the $5 million that it believed was the sublimit that was available. And when Creekstone disagreed with that, Creekstone chose to file in Louisiana. Now, on the point about XL fighting that issue.
In spite of the forum selection clause.
Exactly.
Okay, but let's just stick with that because we have two sophisticated parties and they agree to the jurisdiction of New York.
Exactly.
And it's proper to do that, right?
Right.
But for whatever reason, Louisiana, in spite of the forum selection clause.
Right. And the reason
Why?
that's
Why?
so-
Why was that? Why?
Why did the party file in Louisiana?
Why?
I don't know the answer to that. This particular property was located in Louisiana, though the policy has properties throughout the United States. But the key
the
here,
property and the occurrence all happened in Louisiana, right?
Exactly, but that's why parties, when they have a policy that includes multiple properties throughout the United States, one of the reasons that parties agree to New York law is to provide that kind of stability so that the policy is being interpreted under one set of rules as opposed to the policy being interpreted
So aren't you
under 50
arguing?
different.
Aren't you arguing against yourself right now by saying that the insurance policy was drafted by whom?
I believe that the record does reflect that there was a broker involved. I think Amwins was the broker that actually put it together. It was not XL that put the.
It was not XL's.
That's correct. But at the end of the day, Your Honors, I see that my time is running out. The problem with the Bronx Supreme Court's order is that it encourages this forum shopping. It encourages.
How?
How is this forum shopping?
This isn't
It
forum
says
shopping.
New
How is this
York.
foreign shopping?
Because Creekstone, instead of following the process that was laid out in the agreed upon contract, they decided to take a gamble and see if
They
could
made a
get it
mistake,
in
and now
Louisiana.
you're in the forum that you're supposed to be in.
But you're-
Fantastic. Let's move forward with the case under the law that you chose to be the law that you wanted to dominate over this case.
But respectfully, Your Honor, they didn't make a mistake. They knew what they were doing because
But we got that, and the Louisiana court also got that, and the Louisiana court decided that notwithstanding their purposeful filing of the case in the jurisdiction they had not agreed to file it in, every court acknowledged that you were right on that issue. Notwithstanding that, they said, it's okay, move forward, and New York, you can feel free to send it to New York, but you'll have time on rebuttal, okay?
Thank you, Your Honor.
Thank you, Your Honor. I won't spend a lot of time unless the court has questions for me, but what I would say is the trial court did nothing wrong here in keeping the case. It followed the precedent that was the Louisiana decisions, and it moved ahead because it had the inherent authority once the case.
And let's
was here
talk
to do
about that
something was
inherent
just.
authority.
Of course.
Has New York State codified, one way or the other, guidance on transfers of cases from another state?
No, Your Honors.
And
silent
when
on it.
that happens, when there is no statutory guidance and no decisional guidance in the state, a court is then permitted to exercise its inherent power in adjudicating the case and bringing the adjudicative process forward in any case that is brought before them.
Yes, Your Honor, that's
Is
what
there any
Alvarez-
case law that, or any statute that prohibited the accepting of a transferred case from out of state?
No, Your Honors.
Okay. In fact, our Constitution is only, has only spoken on issues of intrastate, so that from county to county, different regions within the state our codified law speaks to those transfers.
That's correct.
But with respect to, again, intrastate, it is silent.
That is correct.
And therefore, the court did not overstep any statutory or decisional case law in our state.
That is correct.
Okay.
In fact, the decision was consistent with Alvarez, which says when you find yourself in that position, you're not handcuffed. Rather, you make a decision with your inherent authority to do so.
So here's a different question. I was struck by how the Louisiana Court of Appeals referred to the insurance policy as a contract of insurance between parties. Totally same idea, but a different way of phrasing it. So here, is it correct that both parties agreed that to personal jurisdiction in New York?
The contract
contract.
says that the contract for this insured had one property. That property was located in Louisiana. It did not, and although we would get into discovery if the case were to proceed, there was nothing in the record but about whether that provision was negotiated. To the contrary, there would be discovery on whether this insured was somehow sophisticated. What it did believe was that because Louisiana had a statute that required insurers who insure property in its state have disputes decided in its state, that it could file in Louisiana. Ultimately, the Supreme Court in Louisiana disagreed.
And the contract also provided that New York law would apply as to the interpretation and applicability of the contract, right?
The contract says that what the court didn't decide in this case, and the parties haven't taken discovery on, is how those provisions would apply. To the extent it considered provisions, the provision it considered was that for commencing suit.
And the decision, the final decision in Louisiana did not require your client to commence a new action in New York. The direction to the court below was to transfer the case if the New York courts will take it.
Yes, Your Honor. In fact, the record shows the Louisiana court was concerned that if it dismissed instead of transfer, that the case would not get decided in terms of the merits of the coverage.
And to that end, they added a handwritten note that the case wasn't dismissed, so that if New York declined jurisdiction, the case would still be alive, and the Louisiana courts could then decide it on its merits.
Yes, Your Honor.
Thank you.
Can I hear you as to your cross appeal on the default judgment?
Yes. In terms of how we got to a place where the case was being then heard, this case arrived in New York. XL knew it had been transferred from Louisiana, and it essentially decided that it would ignore the fact that it was here and refused to respond. The only reason that XL began to even respond at all was because my client ultimately made a motion to default. It did that, though, only after the case had been here for almost a year, after several emails to XL's counsel, both the Louisiana counsel and current counsel here, after being told that those attorneys...
Also, after all these years of litigation, why would this end in a default judgment?
Your Honors, ultimately, XL, when it came here, my client, when it came here, was prepared to attend to this case. But what it couldn't do was get XL to respond. XL decided it would intentionally
now
ignore
you
us.
have, okay?
Yes.
And we are here, and it seems to me that life should be given to the intention of the Louisiana court. But I thank you.
Thank you.
You have 2 minutes.
Thank you, Your Honors. With regard to the question of the inherent authority and whether or not there is any law on this issue, as we discussed in our brief, when we look at the CPLR and what the process is for a party to initiate litigation in New York, there are very clear guidelines.
But you have just not taken heed to what I just said, which was the court in Louisiana did not direct the plaintiff to recommence an action in New York. The direction was to transfer it. So there was no need, in light of that direction, to follow the CPLR's commencement of suit provisions.
Your Honor, I think the fact that the Bronx Supreme Court actually directed plaintiff to amend its Louisiana petition to follow the CPLR last February shows how messy this transfer was. And the reason that XL did not answer the Louisiana petition under New York procedural law is that there wasn't a mechanism to do that. And in fact, we had been communicating with plaintiffs' counsel, and they understood that our position was once there is a New York action under the New York law, then XL will respond to that. It was, and we expected that they would comply with the CPLR.
That is such an unusual argument. I looked at that like a million times, and I said, they said that they were excused from filing an answer because the lawsuit was illegally transferred. Really, notwithstanding the fact that the Louisiana Court of Appeals did the transfer. I like, oh, this is so interesting. What an unusual litigant we have here.
Well, and Your Honor, the issue was, even though XL knew that this litigation had been delivered to the Bronx Supreme Court, without the kind of direction that happens when the CPLR is followed, there wasn't direction about, well, what in fact is XL answering? Are we answering these Louisiana allegations under the Louisiana law? Should we be turning them into New York allegations?
Law, you agreed New York law, right?
Right, but the petition that they just simply sent back to the New York court was still that Louisiana petition. And that's why the Supreme Court of
So then the
Bronx—
response would have been to send a letter to the court asking for guidance, not, you don't have any jurisdiction over me, I'm just not gonna answer at all.
Well, and again, Your Honor, it wasn't properly served. Even if you agree that, in fact, the
You get
delivery—
served with a transfer?
I'm sorry?
What kind of service do you get with the transfer that
Well,
you're
that's
saying it's improper?
That's the thing, Your Honor. There isn't any guidance about what kind
So
of—
then it can't be improper. If there's no statute that says how it has to be done, how can you say it wasn't done right when you have no guidance? So you're pulling that out of thin air.
And I think, Your Honor, I think your point is exactly the point we're making here. When we allow this kind of interstate transfer to happen without any kind of rules and regulations—
You mean the courts? You mean when the courts direct something, attorneys can decide they're not right, I'm just gonna ignore that?
Well, and Your Honor—
That seems to be your argument. I don't see any statute, I don't see anything that tells me that the court was correct. So I'm going to ignore it.
With Your Honor, with respect, that wasn't what XL was doing, and that wasn't XL's position. XL was trying to respond to the correct—
Is your friend accurate that you didn't respond until they filed the default motion?
We did not formally,
Yes.
XL did not
Okay.
formally respond. That is correct.
So you were glad to get the motion for a default?
No, Your Honor, I wouldn't say that. Thank you.
Thank you. Okay. Thank you. Bay Towers versus Pike.
Good morning, Your Honors. Mitch Rotber on behalf of Appellant Bay Towers Associates. Your Honors, this case requires reversal on summary judgment in favor of all of the Lightstone defendants and against Bay Towers Associates, which I'll refer to as BTA, its initials. It was improvidently granted for three reasons. One, it is completely in opposite to the Birnbaum decision that the Court of Appeals issued in 1989, which tells us that there is an inflexible and sensitive rule that requires one in a position of fiduciary duty to exercise that not only against blatant self-dealing, but also to avoid situations where that fiduciary self-interest might overcome the absolute duty to the fiduciary. And there's no question that there's a contractual fiduciary duty owed by DAL, the general partner in the Bay Towers Company, the limited partnership, in which BTA was the limited partner. On that basis alone, summary judgment was improvidently granted, but it doesn't stop there. 6 months or so prior to the motion having been made by the Lightstone defendants, the court, without reasoning, and on a non-motion, it's a non-motion order, curtailed all discovery, just stopped it against all claims against the Lightstone defendants, which basically meant discovery stopped. And while I expect, knowing having been the litigant there, it was anticipated that the motion would have been made immediately thereafter. It took several months before that motion was made. And of course, that was all made, that delay was consensual. If a counsel asks for more time, it's granted. It's the way we deal. But so we have another order where no discovery was permitted for us to gain enough facts, or more facts, I should say, to overcome summary judgment. The third reason is that even though we had no opportunity for discovery, Max Perry provided an affidavit to this court, a declaration, and his affidavit attests that in July of 2018, there was a meeting at which DAL and others associated with DAL, including the Lightstone Group, which is the umbrella for DAL, met with MPM, who at that time was trying to secure some money out of this.
In the affidavit, he says that he contended that the failure to advise BTA caused BTA to lose the opportunity to negotiate with MPM and others who had an interest, and in the distribution. But according to the agreement, BTA had absolutely no right to engage in the day-to-day operation. That was totally within the hands of the defendant here. There's no question that the partnership agreement cedes to the general partner all management rights, and that BTA has no management rights. But that is not a management question. That is a question about the disposition of the asset. This limited partnership owes... How is that not management?
Because at this point...
Disposition of the asset, how is that not part of your management?
In 2018, this meeting is about...
Counsel, you're not answering my question.
I shall answer your question, Your Honor. I apologize.
Thank you.
It is not management of the partnership, because what is transpiring is a liquidation of the asset, so that the limited partners and others would...
It said he had the exclusive and complete control over all partnership matters relating to and including sale of the limited partnership interest, admission of limited partners, representations to limited partners, handling all relationships with limited partners, finance, tax, accounting, matters relating to the partners, capital accounts, cash distributions, tax elections, and so forth.
That's right. That's
kind of sounds like everything.
It does sound like everything, except that all of that is imbued with the fiduciary duty that's owed under paragraph 7.8 by DAL to BTA.
Yes, but again, the statement in the affidavit by Perry was, he didn't give me the opportunity to negotiate. He didn't have to give him the opportunity to negotiate. He didn't have that right.
Your Honor, in 2018, in that meeting, what's at stake is BTA's interest in the limited partnership. There is nothing more elemental than BTA's absolute interest in securing and maintaining its limited partnership status in the general partnership.
Okay, you'll have time on rebuttal.
Thank you, Your Honor.
May it please the court, David Newman for respondents.
What am I missing?
I'm sorry?
What am I missing?
I don't think you're missing anything.
Okay.
And unless the panel has any questions, I'm prepared to sit down.
No, you go ahead. I was hoping you could elucidate for me what I'm missing.
Frankly, Your Honor, it's hard to understand what the breach of fiduciary duty is. I don't know what information, because the brief isn't really clear as to what information our client should have given to a BTA. So it sounds like it happens to be that the BTA interest was going to be foreclosed upon by MPM. Now, Obviously, BTA had knowledge of that because there was a notice of foreclosure. So they knew ahead of time that it was going to be foreclosed. That's first of all. Second of all, the foreclosure was between MPM and BTA. Our clients, the respondents, weren't party to that foreclosure action, so there's no reason for us to be telling BTA that it's going to be foreclosed upon when it got a notice of foreclosure in the first instance. So I don't understand what the subject of the breach of fiduciary duty is. That's where I get lost in this. But I think Your Honor indicated that there can't be a breach of fiduciary duty if BTA is not entitled to have any management in the operation of the facility. They have no discretion as to management, as to finances, as to mortgage, as to anything else, which ultimately goes to damages because there are no damages. So if BTA is unhappy that its limited partnership interest was foreclosed upon, it brings an action against MPM. It did bring an action against MPM in this proceeding, and that complaint was also denied on summary judgment. So let me turn to discovery very briefly. This action was commenced in July 2018. The trial court granted the injunction as to discovery in October 2021, 3 years. BTA did little to seek discovery from my clients. It did take 2 depositions, one of a non-party and one of MPM, but for whatever reason did not take the deposition of our client. We didn't stop them, so they had 3 years to do that. Lastly, with regard to the Max Perry affidavit, Max Perry, according to his affidavit, is the general counsel of the custodian of records of BTA. He's not a principal of BTA. He has no authority for BTA. So the fact that Max Perry puts in an affidavit to me is of very little significance. Unless the panel has any questions, I'll be glad to end here and just ask that the decision below be affirmed.
Thank you.
Thank you.
You have 2 minutes.
Thank you, Your Honor. Paragraph 7.8 on fiduciary duty in the partnership agreement, and this goes to DAL, which is the general partner, has 2 sentences. One is a very broad one and one is a very specific one. The broad one is essentially ringing the bell that DAL has a fiduciary obligation to the limited partnership, shall exercise all of its obligations in a fiduciary capacity. The second sentence is very specific, and DAL shall have a fiduciary responsibility for safekeeping and using all funds and assets of the partnership, whether or not in its possession or control, and shall not employ such funds or asset in a manner except for the benefit of the partnership, which means for the benefit of BTA, which is a limited partner. That is the essential fiduciary duty that was breached. What happened between 2018 and 2021 was a pandemic. Nothing happened for the better part of 2.5 years in just about every case, including this one, Your Honor. We ask that this court reject the summary judgment, reverse it, and allow BTA to preserve its rights for breach of fiduciary duty against DAL and all the other matters that we set forth in our initial brief.
Thank you. And last but not least, Kaplan versus 55th Street Apartments.
Your Honors, if it please the court, we made a mistake. We made a big one. We submitted a larger brief than the rules require.
Behemoth.
Sorry?
You did it twice.
We did a reply.
So
it was longer.
I mean, it's one thing to do it first time, your hand gets smacked, and you resubmit, and you do it right the second time. But no, you submit yet another brief that's still over the time limit. So why should we undercut the judge below?
Well,
who gave you a shot by, I mean, you blew it the second time.
But we did request permission, albeit late, to file a brief that was
over
not
the limit.
It was over the limit.
Again, by a lot.
My experience since then, and I've learned, of course, is that the courts have, particularly in circumstances like this, where we have a very large amount of material to cover, they have granted me permission to file briefs of 10,000 words or less. So that is pretty common practice, my understanding is. And of course, I've learned that too late, but that is what happened. And that is what has happened to me in the past.
You still can go to trial, right?
Well, we can go to trial, Your Honor, but it's going to have to be on claims that are, we believe, severely lacking in merit.
Well, there's plenty of cases that go to trial where that is the case.
That
you won't
is
be alone.
true. That is true. But I think what the court needs to do, if you'll pardon me, is to decide whether or not the rejection of the papers, which wasn't even a rejection of the papers, the court reserved that right in its local rules to do so, but it did not reject the papers, it denied the motion. And that's a big difference as far as we see it, because there have been several cases where the papers have been rejected, but they were done without prejudice to resubmission. That's, again, that could have been done in this case.
So you wanted a third try?
No.
You got two.
We did.
Both times you blew it. You violated the rules, and now you want a third bite of the apple.
I think that in order to gauge whether or not the rejection or the denial of the motion was reasonable, one needs to look at the way the brief was structured. There was a statement of material facts. There was a legal argument. We could have, and again, mea culpa, we did not do this. We could have simply broken out the statement of facts into a statement of material facts and submitted separately. That would have reduced the size of the brief down to 5,600 words. The court did not consider that. That is something we did have the right to do, but again, we were at year's end, we were short-staffed, we did not have the opportunity to do the right compliance review. And again, mea culpa, Your Honors, we did
Counselor,
this.
if I may.
Yeah.
Usually, when attorneys appear in court, even this court, there are rules in every court, like this court.
Of course.
All right, and I'm sure that you are aware of the rules of this court.
Yes.
All right, and the trial court, Justice Bluth also has court rules.
She does.
Did you look at those court rules?
We did.
So you knew the court rules, but in spite of that, you violated the court rules twice.
Messed up, Your Honor, we did. But again, I think that the primary interest.
Well, let me ask this question.
Yes, I'm sorry.
So you know the court rules, and part of the court rule says, you know, and I'm just paraphrasing, that you should get permission if you want to file,
In excess, yeah.
But you didn't do that.
We did not, but we asked for it at the end.
All right,
And
okay.
that was our mistake.
Even the second time, it was still way over, but you were unable to shorten it because of the extensive factual record. And my question is, what's so complex about a breach of contract and a negligence? What's so difficult about that?
Well, it was a very lengthy set of facts, and what happened in this case, Your Honor, is that there was a separate litigation that was brought, where transcripts, where there were certain admissions made. There were, of course, the deposition transcripts that had to be incorporated. There was an extensive production that had to be culled through. There was there were emails. There were statements that had to be incorporated. This was not a simple situation of either tort or breach of contract.
Thank you.
There was a lot in there, and I do apologize.
Thank you. You'll have a minute on rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court. There's not much for me to say.
Was there oral arguments on this motion?
No, there were no. It was denied outright. And I'm not going to say that there are very few attorneys who have not made at some point in their career a mistake with respect to filing, so I understand that. And in fact, when the second filing was done, respondent did not oppose the second filing. We simply filed our opposition to the motion for summary judgment. Our only argument is that the court had discretion. The judge had the discretion to do whatever she wanted or he wanted, depending on what they felt was appropriate, and that was exercised here. And on the second time, when the second error occurred, the same thing happened. The discretion was used, and that is something that should be respected, and that is something that does not need to be overturned, considering the mistake was made twice.
And in that second filing, what was conspicuously absent from that filing was a word count.
Yes, and you know, obviously, we're going to completely oppose the idea that this would have been granted on the merits. This is a very vehemently opposed motion. There were a lot of affidavits and there were statements. Do I think that it needed to go over the page limit? You know, the word count? No, I didn't. But again, I asked the court to respect the discretion of the lower court and deny this appeal.
Thank you.
I asked for permission. I actually went by page count because I was going by an older rule, to be honest. But when I did my motion, I actually asked to enlarge the number of pages based upon what I had received, you know, as part of the motion.
Thank you. Counsel, you have a minute.
Thank you. Thank you, Your Honors. Just in terms of discretion, the discretion is not unlimited. And I just want to point the court, if I might, to a First Department case and a Second Department case, the crane collapse case, 119 83rd 437, which is a First Department case where the court did assess whether or not there was a reasonable application of discretion. And what the court said, what this court said, is that when a court actually makes a determination of the motion, instead of simply rejecting the papers, that is over the line, and that is an abuse of discretion. What the court did here was actually determine the motion as opposed to simply saying the papers are not compliant, either redo them or submit something else. That's, and again, the same holding in Macias, which is a Second Department case. So that is where we need to start, and so discretion is not unlimited. Discretion must be exercised reasonably.
Thank you.
Thank you.
Have a good night.